has been ordered to pay back the money. It's believed that the first time the President of South Africa has been issued with a personal legal costs. Joining us in studio is the President of the Black Lawyers Association, Mashudu Kutuma. Thank you very much indeed for joining us. Welcome to the program.
Thank you, Peter.
What we are going to talk about mostly is judicial overreach.
Yes.
But I suppose we can't ignore today's judgment, because there will be some who are already worried about judicial overreach who have a view about today's judgment against the President. Your initial reaction from what you heard Judge Dunstan say?
Obviously, from what I heard from the judge, reading that unanimous decision of the Pretoria High Court, it's very encouraging, because what the court is mindful of is the Constitution and the powers of the public protector, wherein it's been challenged by the President. Remember, the President is the first citizen of this country. He must protect the public protector first. For in this instance, you had the President who intended to challenge the remedial action. But they conceded in court to say they think, at the last minute, they think that the public protector's findings are binding, which they will always say, no, it's not binding, it's a recommendation. But central to this decision is also the issue of cost, because the President, for the first time, if you remember, President Mandela went to court with Rugby South Africa, but he was not ordered to pay, because in actual fact, President Mandela won that case. In this instance, we have got a sitting president that is ordered to pay personally from his pocket. I think it discouraged other public figures, particularly even administrative people, to when they exercise their administrative action, they should know that they can be personally held liable.
I would imagine that, you know, what the message is saying is that when a judgment is handed down, pause for a moment, read the judgment, because we were getting a sense that people appeal even before they've even read the judgment.
Indeed, but what prompted the judge when I read the judgment is because it has been found even in the previous judgment of the corruption, was that the President, full well knowing that he has no defense, he insists because he's buying time. So I think it's a huge step towards a right direction in the country, particularly now when people, because this Parliament has initiated these acts, the National PA Act, the Public Protector Act, but they've never been thoroughly interrogated in court, because courts are there to interpret the law, and I think that it's interesting.
So there will be definitely some politicians who've been speaking out against these judges. The President himself has been worried that the country is being run from the courts now. Tell us your thoughts on this idea of judicial overreach, and have you seen any evidence of that?
The BLA honestly condemned this terminology. The BLA still believes that the judiciary is still very much independent in this country. It is only now, for the past 3 years, that you had these issues of judicial independence. If you look at the watershed judgment of S versus Mkonyana that abolished the death sentence, nobody says that is judicial overreach, because the Constitution says right of life. Then the Constitutional Court says you can't have the death penalty. That was not judicial overreach. Even in these two judgments, the first one that came out on Friday, clearly the President is conflicted. But however, the President have got right to appeal or to bring a review, but not to condemn the judgment or the judges themselves. Judges make mistakes, hence you have got lower court and superior court. In this instance, you have got a full court. A full court means, full bench means it's 3 judges who are sitting, discuss the matter, advise each other, and come to a conclusion. It's unanimous. But in the event that the President is aggrieved by this judgment, he must appeal.
Right. But this time there's a danger that it's at personal cost. So what the judge also spoke about often was that the public have an interest in this, and the public need to see justice being done. But we were just, we were hoping that let's take a look at what the public have been saying about this judgment. The first one, Justice Dikgang Moseneke, I'm not sure that that's his tweet account, but who knows? It says we are bound by the law so that we may be free. Floyd Chivambu from the EFF says that, well done, National Chairperson Commissar Advocate Dalimpofu, for advancing a rationally superior argument that Zuma must personally pay for the legal costs in the process of the delay tactics. He and all officials will now think twice before they approach the courts for nonsense, as he put it. And the opposition leader for the UDM, Bantu Holomisa, they're saying that Jacob Zuma loses 2 cases within 2 hours. Judgment. Court endorses PP's public protector's remedial action. Bravo, thanks Tuli. And trade union leader as well, Mavabi. Finally, Jacob Zuma will feel the pain that we've all felt for his abuse of the justice system. The days of filibustering are coming to an end. He's paying personally this time around. Let him appeal as usual so that he can pay even more. All right, so political leaders also sort of weighing in there, but looking at social media generally, I think the public quite curious to see how this was going to go. We're definitely breaking new ground with this judgment.
It is, because more than any other thing, it assures the public that whenever the public protector has investigated their complaint, thoroughly hear the evidence, make the finding, those findings are binding. Remember, the public protector is a Section 9 institution. It does not only investigate the president, it investigates all public abuses, be that by a nurse, by a teacher, or any other public official. So the public should be happy that at least if they've raised the concern, they've lodged a complaint to the public protector's office, those recommendations that are made there, they will be binding and they will be implemented. And the remedial action will have been thoroughly thought, like it had in the issue of the state capture report. And more so because the state capture report deals with the Constitution. The president has to exercise his power without fear, favor, and prejudice. So if you have got a president that is captured like the allegation that is there, then you don't have a constitution in this country.
All right. Unfortunately, we've run out of time, as we always do with issues that are huge and big. But thanks very much indeed for your insights and your thoughts, particularly on judicial overreach. So Mashudu Kutuma from the Black Lawyers Association, the president of that organization. We're going to take a quick break.